stand while I talk. It makes me a little bit more, I don't know, emotive. Um, Thank you for the introduction. Like she already mentioned, I'm a researcher at the University of Lapland, and I have been doing my PhD there for a couple of years already. Started in 2020 September, and at this point, I'm hoping to be nearly done with the PhD, maybe in a year or so. What I'm presenting to you today is essentially the second article that I have written as part of the PhD research. The program consists of 4 articles, and this is the second one. And when I submitted this abstract to this conference, it was still a work in progress, and I was still waiting to actually get it published. But just a few days before this conference, I finally got confirmation that it has been accepted for publication in the International Journal of Children's Rights. So I'm very pleased to present this very ready work in that sense this time to you. So for my second article, I wanted to look at shared parenting in more detail, and specifically whether legal measures taken by states to encourage it could be considered to be in the best interest of the child, and what the European Court of Human Rights has to say about that. Great, this works. Here is the general outline. I don't know why it's only giving me one pointer at a time, but this is basically the structure of my article. So I first looked at more specifically these individual instances of how these institutions have interpreted shared parenting. And then I presented my arguments for why we should consider shared parenting to be in the best interest. And then also, for the sake of a balanced review, I also presented some arguments that have been presented against it and drew some conclusions. Now, these first parts are probably quite familiar to all of you, so I will not take too long with these, but essentially the best interest of the child is, of course, the key concept here. We know it comes from the Convention on the Rights of the Child, but the UN has also had other things to say about it. For example, in its General Comment 14, where they emphasized the right of the child to be cared for by both parents. And this is, of course, very relevant when we look at the European human rights regime, because these international institutions have a huge impact in shaping children's rights legislation, as has happened with the CRC. But of course, the Council of Europe has gone further than that. This is probably also, this might be familiar to some of you, but the Council of Europe has actually very explicitly recommended shared parenting practices in its resolution 2079. Now, despite the fact that the Council of Europe has taken a very sort of clear stance on the issue, the European Court of Human Rights isn't quite as clear. And that is, of course, the greatest point of interest for me, because the European Court of Human Rights has a massive impact on how European states view these issues. Now, there is no generalized stance before the European Court of Human Rights on shared parenting. However, there are some principles that can be used to see to use as a map as to what the court actually thinks. They are committed to preserving the parent-child bond, and essentially they offer states a wide margin of appreciation, which means the discretion of the state to apply different human rights rules how they see fit. And what is interesting is that when it comes to parental rights, this margin is narrower, meaning that the court is very willing to point out inadequacies in a state's protection of these aforementioned rights, particularly when it involves children and custody. Now, Some things that the court has explicitly mentioned is, of course, the mutual enjoyment by the parent and the child of each other's company, which is an essential element of family life as provided in Article 8 of the European Convention on Human Rights. And they have also explicitly stated that care from both parents is generally in the best interest of the child. Again, this is a blanket statement, so they don't necessarily apply this in all situations, but the assumption seems to be there nevertheless. And this, of course, looks very promising for advocates of shared parenting. It's also interesting that they have recognized the importance of paternal care specifically, because when sole custody is the norm, typically it tends to go to the mother, although of course there are exceptions. Now, something I have highlighted in this paper are a few particularly interesting cases. I already talked about these two cases in my first article. If you are interested, I can send it to you later after the conference. But essentially what these cases were about was that there were couples who had a child born out of wedlock. And in both of these instances, the father faced difficulty in court over custody matters because the state would not even consider joint custody. Why? Because the civil codes of these two countries basically gave mother the veto power in these instances. So in a situation where a child was born out of wedlock, the mother of the child got automatic custody. The father did not. And if the father wanted to apply for custody, they were basically dependent on the consent of the mother to do that. Otherwise, they couldn't. Even under the best interests assessment, they were not allowed. Basically, the state was not allowed to look at whether joint custody would have been in the best interest of the child. And in principle, the European court, did not object to this sort of automatic custody being given to the mother. However, what is interesting when looking at shared parenting is that they do require the opportunity to at least assess whether joint custody in a particular situation would be in the best interest of the child. So again, not a very definitive statement, but it certainly gives us a little bit of indication that what I'm going to be discussing later on in this presentation, there is a certain logic to be had in the European Court's approach that failure to consider shared parenting in itself could be considered a human rights violation. Now, I am not going to spend too much time on these national examples because you have already heard about most of these countries from much more detailed presentations so far. But I did refer to these in my article, one of them, of course, being Spain and Catalonia, which is known to have a very sort of advanced practice in the field of shared parenting. There is also Belgium, one of the so-called forerunners also in this field. I believe there was a presentation on the Belgian situation earlier today. So again, I will not be going too much into these. The reasoning, of course, is very interesting in this case because it relates to how national legal systems sometimes, how they combine shared parenting with the best interest of the child. This has relevance for the European Court's practice as well. Sweden also has emphasized that particular attention should be given to shared parenting in the assessment of best interests. And finally, Norway, which has a political policy in the country to equalize the sharing of childbearing responsibilities. Now, these were just examples, but what the real meat of my paper was was these arguments. So can we say that these legal measures, if a state adopts them, could they be considered to be in the best interest of the child by default? And once again, the psychological considerations, of course, that is not my field exactly, but I have included it because they are relevant to assessing the best interests. We know, and there have also been very good presentations on these psychological aspects. We know that conflict is the most harmful to the child, and especially the diminished relationship between a parent and child. That is where the biggest harm to children comes from. And shared parenting, of course, can be a way to mitigate this. Of course, we still do have to keep in mind some deficiencies in some of the studies, meaning that there could be selection biases in some cases, and the sort of the relationships between cause and effect are not always super clear. However, I think we can say with a high degree of certainty that indeed it is the case that children do need both of their parents, and that is the healthiest predictive element for children's outcomes. Of course, the legal considerations is the most interesting to me. Now, one reason to consider shared parenting to be in the BIC, the best interest, is the fact that it guarantees the protection or the right provided by Article 9 of the CRC, which has to do with the child's right to have a relationship with both parents. And I emphasize here that I'm focusing on the legal elements here. Of course, that's why I refer to specifically to these legal provisions. There's also the fact that sole custody pushes parents towards a custody battle. This is also something we've heard about before, and I believe there was an interesting conversation last night at the dinner concerning this as well, how the legal encouragement of joint physical custody can mitigate some of these custody battles in practice, which is, of course, also beneficial for the child's welfare. Now, this is an interesting one for me. The best interest of the child, of course, is a very ambiguous principle. It's applied differently in each individual circumstance, but the ambiguity of the principle is also a problem because there is no way to guarantee that it is always used with the best interest of the child in mind, even though that is technically what it's meant for. However, a legal presumption for shared parenting could clarify the scope of the principle a little bit. The agreement that shared parenting is in the best interest of the child would automatically give some predictability to what the best interests of the child actually are. This, of course, does not preclude exceptions, but it's rather a question of focus, a question of what takes precedent. And I think together with the protection of Article 9, we can say that the best interest of the child can be said as a default rule to be served by shared parenting practices. There's also the point of accessibility of shared parenting in itself, because apparently shared parenting tends to be more accessible to high-income families, at least in the current state of affairs. And the argument goes that by legally pushing towards more shared parenting, you could make this practice more accessible to low-income families that don't necessarily have the resources to arrange for it themselves. And this is based directly on societal data. Yeah, there seems to be a link between income levels. So it's also a very important equality question in this sense, and especially for children. Children coming from lower income families have a lower chance to be in a shared parenting scheme. So a legal push towards that might be beneficial for them. And there has been success with this approach in Belgium. And finally, the important influence of international law. So if on an international playing field, like before the European Court of Human Rights, a decision can be, or a consensus can be arrived to that shared parenting is by default in the best interest of the child, this is probably one of the most effective ways to affect the custody situation in all across Europe. So the international level is particularly important here. And as I mentioned, the CRC is a good example of that. Now, there are some arguments that have been presented against this notion, and for some reason it reveals these in a wrong order. I don't know why it's doing that, but we can start with number 4. So this is a sort of a counter to one of the points from the previous slide. So on one hand, equality, making shared parenting available to low-income families. On the other hand, one could argue that since this division exists, there might be a reason for that, and perhaps lower income families are simply not able to handle such a system. By the way, I'm not saying that these are arguments that I personally stand behind, but they are important to address as part of the wider debate. Okay, there's number 1. So there's also there's no clear evidence on what specific type of shared parenting in a sort of a legal sense would be best in promoting children's welfare. We do have pretty good ideas on how to go about this, but I would probably agree that more research is always useful and always needed, especially when the legal field is involved. And there is, of course, the fact that joint physical custody is not always beneficial in every single circumstance. We've heard about very serious high conflict or abuse cases, for example, very extreme examples. Some have put out the argument that the benefits of shared parenting can also be achieved in a sole custody situation if both parents are involved in the care of the child. But of course, one of the reasons for advocating legal support for shared parenting schemes is the fact that this is not nearly always the case, and it would be beneficial to push, in that sense, parents towards bringing out the different benefits. Also, this number 3 runs as a counter to what I mentioned about the best interest of the child being clarified potentially by this consensus. There is also concern that having a sort of presumption towards shared parenting could hinder adaptability of the principle, which of course is very important because the whole point of the best interest principle is its adaptability. So it's something to be kept in mind. But finally, I arrive to my conclusions, my recommendations, what I basically find throughout this research. And again, it's revealing things in the wrong order, so it gives maybe the most important point first, but that's okay. This is also, by the way, probably the takeaway I would like to submit regarding what is the most important thing about this paper. Basically, that legal means to encourage shared parenting could be seen as positive action by states to advance the best interest of the child, which is essentially the answer to my research question. But the other points. So a potential model, of course, for a working joint physical custody scheme is having it as a standard element of the best interest of the child with sole custody reserved for exceptional situations. This would have the benefit of clarifying the best interest of the child, but I believe that having this kind of a legal presumption would not be too restrictive for adaptability because it allows for exceptional situations, and it is more of a matter of focus and emphasis rather than a hard-locked rule. Interestingly, as I already mentioned with regards to the Sporer and Zonecker cases, one could argue that the European Court of Human Rights already sees, in a way, shared parenting in general terms as an element of the best interest of the child. Obviously, they do not state it very clearly or in a very direct manner, but I think that kind of an approach can be inferred from some of the court's case law. And of course, the question then is, would failure to provide for shared parenting practices, would that be contrary to the BIC and also through the insufficient protection of 7, 8, and 9 articles of the CRC? Of course, it's very important to note that all of these articles of the CRC have an indivisible nature, as the CRC committee itself has stated, meaning that these rights, the fulfillment of the rights of Articles 7, 8, and 9 connect very strongly to the best interests. And of course, there's Article 8 of the European Convention on Human Rights. Yeah, everything was a little bit out of order. So I was going to finish with the blue box, but I already kind of did that. So I suppose that would be it. Here's oh wow, okay. I was hoping for it to just give it in one go. This looks a little bit odd, but if anyone wants to check some of the sources I've used specifically for this presentation, you can do that. And thank you so much. If you have any questions or want to discuss things further, you're always free to send me